Yeah.
It may sound silly to compare it to a contract to build a house or something, but in reality, in some ways, it is the same. You get a benefit, the car you're buying. The seller gets a benefit, the cash for the car. You do it for those reasons. The seller loses something, the car. You lose something, cash. So it makes it very simplistic, but a plea agreement.
And just to give you a little information, so contract law, that's called a bargain for exchange. Both people give up something, right? And it's called consideration, just so you know. Promise for a promise, promising to do or not do something. In this case, I promise not to give you as harsh of a sentence, and you promise not to engage in the same behavior. So there's a bunch of different ways you can enter into a contract. It can be with money, it can be with a promise, but you've got to take some kind of an action. If it's just with a promise, or not doing something could be considered consideration, for example. Let's keep going.
It really should have a benefit to both, and there's something you both give up.
That's right.
This on paper alone shows a benefit to the state to me and a benefit to you. That's just paper alone. That's not the basis behind the paper, like the arguments, legal arguments that you believe you have, Mr. Myers, and whether you think you can win this case either in trial or appeal. That's a separate issue, but it is important that you consider the fact that you could get convicted in a lot more prison time. And Ms. Stiles, if I'm correct, if he's convicted at trial, there is some mandatory.
By the way, thank you, Gloria. Thank you.
Yes, of everything as charged.
So if he has prior convictions, they're old, and they would make the prison mandatory even if he's just convicted in one felony at trial. And then because of the separate dates, he faces the possibility of stacking and that maybe even treated as a category 1 repetitive offender. And then on the second case,
okay, just so you understand, so in the prosecutor's business, because I also worked for the prosecutor's office for the city of Los Angeles, you can have concurrent sentences, you can have stacking of sentences. So there's all these different ways that the judge may decide to concurrent, or anyways, we'll get into this in another show. But just because he's entering into this plea deal doesn't mean the trial judge still won't throw the book at him and give him time served. So it's pretty scary to enter into a plea deal when you feel that the trial judge is biased against you, and you just tried to get that trial judge thrown off the case. Judges are people too, guys, and I'm not saying that this judge is or isn't biased, because I'm not the lawyer on the case, and as an officer of the court, I'm not going to pass judgment on him. I'll let you guys and Lane Myers make up that decision. I can say that based upon the argument that Lane made, I feel that he had a powerful argument that the judge saying, by you electing to represent yourself, in effect, you've disentitled yourself from being able to timely file and receive pleadings and paperwork in order to prosecute your defense. That's just from my personal opinion, if this was in California or Texas. So because I'm not licensed to practice law in Arizona and I am an officer of the court, unfortunately, I'm not going to put myself in the precarious position of ending up like Lane Myers, especially after I saw what happened to him.
Also had this allegation, which was then in prison. So yeah, it has 2 years.
2 years is flat, isn't it?
So and that's
am I right, Mr. Resnick, that 2 years is flat?
yeah.
Well, so the benefit to the state is if you enter the plea.
Something I didn't do.
Well, if you didn't do it, sir, you can't enter a plea. So
I didn't do it. I just entered the plea. The only reason I would enter the plea is because I haven't seen my parents in 5 years, and they have been planning to come to Tucson next week for 8 months. Which the state is aware because they listen on my calls and read on my messages. So I mean, the only.
well, they'll be here then either way.
Beware.
Whether you go to trial in July or whether.
No, I mean they're coming to visit next week. They live in Michigan.
But I thought you said for 8 months.
No, we've been planning this for 8 months.
I apologize.
This is something that was in the works for 8 months, and now suddenly I'm in jail. They're driving across the country to visit my sister. They're 70 years old. The state is going to argue against me being released today if I enter this plea. So to me, the benefit would be that I get to see my parents who I haven't seen in 3 years. I get to go home and take the videos down and direct the attention. Then the videos will be, oh, look, the judge did the right thing, or the court did the right thing, and they let this guy out of the gulag because he should have never been there. But it doesn't seem like the state, I feel like the state is disingenuous.
I think Mr. Myers is hoping that I'm going to change my mind and agree with his release. I can tell you that will not happen at So you can keep talking about it, throwing that out there, it will not change. And I stress that to him. My belief is that he needs to be in custody until sentencing. He had his arraignment on the first case, and that very weekend, he went and committed new felony offenses against his victim.
I would say it right at the outset. Objection assumes facts, not an evidence. But this has not been adjudicated. Allegedly, the defendant committed a felony. I have a lot of problems with the way it's being framed. The framing here doesn't look good. Oh my gosh, thank you so much, Clay. Clay Foundations just threw me a super sticker. Hold on, guys. Make sure again to like and subscribe to Clay. And almost looks like Rick Jonesy, if I'm not mistaken. But man, you guys are awesome. Hey, I'm going to have a nice steak dinner tonight, man. Maybe I'll be like that lawyer who has the storage facility that talks about how he likes to get a steak and a nice glass of wine after he makes $20 doing a family law case. Oh, maybe I'll make a big payday. All right. All right, let's get back into it. So really quick. Dude, it is Brick. Right on. Hell yeah. Good seeing you, Brick, man. You know you're my homeboy for life, man. I really appreciate it that you were there to support Chili when so few people were, even though he was innocent. And that really irked me big time, the way that so many people assume that just because you're arrested, just because you're jailed, that means you're guilty. That is very communist Chinese, Mao Zedong, Joe Stalin-like. It goes against everything our founding fathers stood for. All right, so you were definitely a great guy, man, a good man. Let's get back into it.
I understand it's alleged. I understand.
And so, I have concerns if he is not supervised by probation. We made it probation available, but it comes with a lot more conditions of release and a lot more monitoring than does pretrial services. And pretrial services, him being out before was not enough to stop him from doing this. And so if he's giving this speech right now, hoping that I'm going to change my position on that, I can tell you it's not going to happen. And if he would like to go to trial, we are ready and, to go to trial. So he can make his choice. So if he wants the plea, it's available to him today. If he doesn't want the plea, we're able to go to trial.
Yeah, I don't think I was trying to get.
Can you do it? Hold on 1 second, Mr. Mayor. Can you do a Donald record today about that information? It's okay if you can't, I just wanted to.
I'm starting to write.
So a Donald record sounds like some kind of a case that they'll call, a Wheeler motion or something. So a Walker hearing or whatever. So they'll call hearings and motions and proceedings by a name of a case that came down, and that somebody wants to Google it and throw it in the sidebar for me. What is a Donald record? It sounds like some kind of a record when they entered into the plea, so the court, or if he gets violated again, can go back and look at that, and they call it. It sounds like it's called the Donald record. I don't know. If somebody knows, tell me what it is and put it in the sidebar. I'm not looking right now at the sidebar. I'm scrolling to make sure you guys can watch, because the audio, unfortunately, under the 122H rule, apparently has been disallowed because the husband of the victim, who's also a prosecutor, the alleged victim, the complainant, has a petition to disallow people from audio recording in court because somehow that's going to interfere with the proceeding. I see absolutely zero basis for that. I think it's absurd. I think it's definitely overreach and definitely goes far beyond the separation of powers doctrine. And I also, even though I'm not a resident of Arizona, did voice my concerns in that petition online. Let's keep going.
I know that. I know it's a lot of math.
What is that?
Okay, so the Donald record, that's a case, and it basically says that.
Oh, there it is.
So if you accept a plea, I have to find that you knowingly, intelligently. If you reject a plea, I need to know that you knowingly, intelligently, and voluntarily reject.
Yeah, we do the same thing in California. We have a different name for it, but it's the same thing.
You can't knowingly or intelligently reject something you don't know what you face, for example. So if you have no idea what you face being convicted at trial, how are you knowingly rejecting the plea agreement?